So welcome to the LBTT and ADS webinar this morning. Thanks very much for joining. My name's Isobel. I'm head of corporate tax and incentives at Brodie's. My colleague Bob Langridge, who's a senior associate in the corporate tax team, will also be speaking at the webinar. In terms of asking questions, please use the Q&A function at the bottom of the screen to post your questions. You can remain anonymous if you wish, but if you want to put in your name, it means we could follow up with you afterwards if we don't have time to get to your question. So the agenda this morning is dealing with LBTT penalties, reasonable excuse in COVID, holiday accommodation and some other residential, non-residential issues, missed relief claims, how you deal with missed relief claims, because there's a bit of uncertainty and so on out there about how you deal with them. Linked transactions, some practical approaches to dealing with them, and when can ADS be charged on a main residence. So I'm going to hand over to Bob to talk about dealing with LBTT penalties. Bob.
Hi. So the purposes of this, we're going to have a quick canter through the sort of main penalty regimes that apply to LBTT and the things that can be done about mitigating them, some kind of pro tips on how you can approach this, as well as just looking at what Revenue Scotland have been saying about COVID-19 pandemic, particularly the lockdown period. First of all, then, a very high-level review of the LBTT penalty regime. We effectively have, for LBTT, 3 penalty regimes, all of which are contained in Chapter 8 of the Revenue Scotland Tax Powers Act. By comparison, old SDLT, we had 1 penalty regime. The 3 penalty regimes we have are 1, a late returns penalty. This kicks in 30 days after the effective date of a transaction. You get charged a flat penalty of £100. Next, there are daily penalties between 3 months and 6 months of £10 a day. And then at 6 months and 12 months, you have a penalty of either £300 or 5% of the tax, whatever's highest. At 12 months, that penalty can rise to 100% of the tax if the failure to file a return is deemed to be deliberate. We also have late payment penalties. These are slightly different. The first penalty arises 60 days after the effective date of the transaction, and then 6 months and 12 months later, and each of those is 5% of the unpaid tax. Those 2 kind of doing things late penalties effectively form one kind of regime, and I'll talk about them jointly. The other kind of penalty we have are inaccuracies and returns penalties. So this is where a return has gone in but contains a mistake, and that mistake results in an underpayment of tax. The general approach to these is that if the error is careless, the penalty will be 30% of the potential lost revenue. And if the error is deliberate, it'll be 100% of the potential lost revenue. There are some slightly complicated rules about how you determine what the lost revenue is. These are not relevant to today. So moving on, the late things penalty. The first thing to note about these, which I think sometimes people miss, is that these are cumulative. So not only do the penalties under late returns and late payment accumulate, but they accumulate between them as well. So you can't set off a late return payment against a late payment penalty either. So in the worst case scenario, you could be paying £1,000 plus 120% of the tax. In order to trigger a penalty, Revenue Scotland have to give notice to a taxpayer setting out the transaction and or the time period to which the penalty relates. General rule about timing is that Revenue Scotland have 2 years from the date on which you should have done something and you haven't to issue a notice, but this can be extended out longer, particularly if penalties are being issued as part of an inquiry process. A couple of years ago, we had a debacle about the daily penalties for late returns. This was settled in the case of Revenue Scotland against Begbie's Traynor Central LLP. I've given you the citation there. And the idea here is that because the daily penalties section contains a standalone requirement that notice must be given, in order to charge those penalties, Revenue Scotland effectively have to give 2 notices to taxpayers. They have to give a notice saying that they are charging a late payment penalty and a separate notice that they are charging daily penalties. However, that second notice can be retrospective. They don't have to issue it before they start charging the daily penalties. Moving on to mitigation and what you can do about them. Now, again, everything you can do here, like how Revenue Scotland will issue a penalty, is completely prescribed by the Revenue Scotland Tax Powers Act. And the starting point for this is that any decision the Revenue makes about these penalties are what are called appealable decisions, which means that taxpayers have a statutory right to 2 different forms of remedy if a penalty is issued. They have the independent review and they have the Tribunal Appeal. Now, when we are dealing with or trying to resist penalty notices, we always, and I think without exception, advise people to go for the independent review before they undertake a tribunal appeal. To trigger an independent review, you have to issue a request for a review within 30 days of the issue of the penalty notice. The reason we always do the independent review first is you cannot undertake an independent review or request one if you are already appealing a decision. The other reason we do it is that this is often the first opportunity for a taxpayer to present their case and argue against the penalty. Unless you've made submissions when a late return or a late payment is made, Revenue Scotland will not really think about things. They will issue the penalty notices, and then it's up to the taxpayer to respond to them. So this is really your first response, is undertaking an independent review. Therefore, it's really, really important to ensure that what you're saying in your independent review request is relevant. If Revenue Scotland undertake the review, they can come out with one of 3 things. They can uphold the initial decision, they can vary the decision, or they can cancel the penalty notice. There are 2 really, really important things, though, that you need to bear in mind about independent reviews, and these are things we see all the time going wrong. The first thing is you only get one shot at an independent review. If you don't like the answer, you can't ask for another one, you can't adduce more facts. So your first request really has to have everything in it. It's a one-shot chance. The second thing, and this is where we as advisors can sometimes shoot ourselves in the foot, is that well-meaning advisors can inadvertently trigger an independent review, but without actually saying anything relevant. Normally, this will happen, and we see this a lot, several times a year, I would say, because an advisor's administrative processes have failed. It means a return's gone in late or tax has been paid late. Maybe the advisor has been overwhelmed. They get the penalty notice in, and rather than coordinating a response with their client, they will write back and say, thank you for these penalty notices. This was an error on our part. It wasn't an error made by the taxpayer. This went wrong at our end, so we'd like you to reconsider. You may not realize it as an advisor sending in that letter, but that is formally a request for an independent review. If you send in a letter like that, I will guarantee you have said nothing that is relevant to the independent review process, and that penalty will be upheld. And then your only response is to go through to a tribunal appeal. A tribunal appeal, unlike the independent review, is full-on litigation. You are appealing directly to the tax chamber of the Scottish first-tier tribunal, and it is a lot more expensive and time-consuming, and there is a lot more detailed process that has to be followed. This process is governed by legislation, the tax chamber rules for the first-tier tribunal, and while this is much more flexible and relaxed than the process to be followed by higher-tier courts, it is still a lot more involved. If you want to trigger a tribunal appeal, you must request this directly from the tax tribunal. There's a form you fill out, and that has to be within 30 days of the penalty notice or the conclusion of the review. The tribunal itself will stream 3 kinds of cases: paper cases, basic cases, and complex cases. And it's worth noting, again, like the independent review, that you really have a sort of one-shot with a tribunal appeal. Most reasonable excuse cases, and we'll talk about this in a minute, but most penalty appeals are by their very nature very fact-specific. And the only court with authority to act as the arbiter of facts is the first-tier tribunal. So if you fail to plead relevant facts to the first-tier tribunal and you wind up appealing the decision to the upper-tier tribunal, they will not allow you to revisit those facts and plead alternative facts. You will be stuck with the facts you pled first time around. Next slide. So, how do we keep things relevant if we're requesting a review or undertaking an appeal? I think there are really two approaches that are worth taking here. The first one is sometimes to consider, well, actually, was a return even required here? Because if there's no filing obligation, the penalty legislation isn't triggered. This is most common, I think, when people put in returns in order to facilitate registration at registers of Scotland. You know, sometimes you're dealing with a zero consideration return or some funny exemption. People will put in an LBTT return just to make it easier to register the transaction at the land register. And that's always a good thing to argue if you can. Also, under special circumstances, Revenue Scotland can agree to reduce the penalty. Special circumstances ain't defined in the legislation. So what we would generally try and fall back on is the reasonable excuse argument. Under the RSTPA, if the taxpayer can convince the revenue or on appeal the tribunal that it has on the balance of probabilities a reasonable excuse, then no penalties are due. First thing to notice about that is it's for the taxpayer to prove on the balance of probabilities that they have a reasonable excuse. Secondly, reasonable excuse isn't defined within the legislation, but it is a recurring theme throughout UK tax legislation. So it is probably one of the most heavily litigated word couplets you will find. There are some things, however, that are specifically defined not to be reasonable excuses. In the statutes themselves, lack of funds is not an excuse, unless the reason you have a lack of funds is something outside of the taxpayer's control. Also, reliance on others, I got my agent to do it and he messed it up, is not a reasonable excuse unless the taxpayer themselves have taken reasonable care. The point about both of these really is that it has to be the taxpayer's reasonable excuse and not the agent's reasonable excuse. It's what the taxpayer has done that counts. Another thing that's commonly cited as an exclusion, but is a bit more of a grey area, is ignorance of the law. For a while, this has been treated as a truism, but a recent tribunal case from 2019, Cott against Revenue Scotland, did state that that ignorance of the law could be a reasonable excuse, but effectively argued that the bar for that is quite high. In that case, Mrs. Cott wasn't successful in her appeal. So, given that this is so heavily litigated on, I'm going to just canter through a couple of decisions which have had some useful things to say about reasonable excuses. And being a lawyer, can't talk about litigation without lodging my caveats. My caveat here is that most reasonable excuse cases live or die in the first-tier tribunals. So the majority of these decisions aren't binding, but they are informative and useful. On the general concept of reasonable excuse, I think the cases of Perrin and Irby are quite useful touch points. In Perrin, they very strongly make the point that when you're looking at the reasonable excuse, it's all about the specific taxpayer. The issue is whether that particular taxpayer, court's emphasis, has a reasonable excuse. The experience, knowledge, and other attributes of the particular taxpayer should be taken into account, as well as the situation in which that taxpayer was at the relevant time or times. In Irby, and I really like this decision, the court sets out a bit of a rebuke to the revenue. And this is a rebuke to HMRC, I should say, for a fallacy of denying the antecedent. One thing you see revenue authorities arguing a lot in the case of reasonable excuses is it was reasonable to do X. If you had done X, that would have been reasonable. You did not do X, therefore you are unreasonable, therefore you have no reasonable excuse. And Irby sets out quite pithily, that this is wrong-headed. The categories of reasonable conduct encompass more than one course of action. Our task is not to identify a reasonable course of action which Mr. Irby did not take, and deduce from the fact that he did not take it that he had no reasonable excuse for the course of action he did take. Our task is to examine what Mr. Irby did and determine whether what he did was the action of a reasonable person. So although the revenue often like to play kind of counterfactual and hypothetical games when talking about a reasonable excuse, the litmus test very clearly expressed in Irby is what they did reasonable, not could they have done something else. Moving on the concept of reasonable care then and relying on an agent, this is slightly more tricky because it's a narrower test than reasonable excuse. And probably one of the most persuasive statements on this is the statement in the Clean Car Company case, which is that if a taxpayer had taken reasonable care, such a taxpayer would give a reasonable priority to complying with his duties in regard to tax and would conscientiously seek to ensure that his returns were accurate and made timeously. In other words, taxpayers appointing someone to do something for them aren't absolved of all responsibility, and they can't simply be passive participants in the process. An upper tier tribunal case, and I think this is probably an obiter comment, but still very helpful, classic land and property. The judge there said, I can see the sense in the underlying principle that even a taxpayer in classic position takes reasonable care only if it puts in place some simple mechanism to assure itself that a signed tax return becomes, via its agent's actions, a signed and punctually submitted tax return. For example, a taxpayer, when sending its signed return, might ask its agent to confirm submission to Revenue Scotland in a short email to the taxpayer. So just saying to your agent, can you deal with submitting the return, isn't reasonable care and therefore isn't a reasonable excuse, unless either you've got something in that specific taxpayer's circumstances that mean that perhaps the test for them is a little looser, a little gentler, or if it would not have been reasonable for them to follow up and chase their agent. For example, if the agent has said something or provided them with information that leads the taxpayer to believe that a return has been submitted. In our experience, this does not have to be as comprehensive or conclusive as an email stating that a return has been made. It could be a state for settlement, for example, detailing an amount of LBTT. We have had a penalty reduced on the basis that a state for settlement had a handwritten tick with the words paid and a date inserted by the solicitor, when in fact the monies hadn't been paid. COVID-19 then. So Revenue Scotland temporarily suspended penalties between March and November 2020. They're now resumed and being issued. However, for that period, the Revenue will accept that business disruption due to COVID-19 can be a reasonable excuse. But that reasonable excuse still has to be shown and argued. It's not an automatic get out of jail free. And one thing I would flag on this is that the reasonable excuse legislation does make it clear that when the circumstances giving rise to a reasonable excuse end, so does your reasonable excuse. You know, if you're only failing to submit because of business disruption that maybe means you don't have funds, once your business is on a more even footing and you do have funds, the expectation is you would pay the tax promptly after that. The one exception to this being a sort of you still need to prove it rule is for lease 3 yearly review returns. Here, the Revenue have taken the position that any return that was a 3 yearly return or termination or assignation return that was due between the 23rd of March 2020 and the 31st of August 2021 won't bear any penalties, provided that the returns are submitted timeously, and if a penalty notice is issued before the return goes in, that the return is submitted within 92 days of receiving that penalty notice. It appears from what the Revenue have said that they view this as applying automatically. You don't need to prove a reasonable excuse. They will just switch off the penalties if you get your returns in on time. Very, very quickly then, brief overview of the inaccuracy penalties. These are slightly different. They're different in a couple of ways. Number one, they can be offset against late filing and late payment penalties. They don't stack with them. Secondly, we don't have a reasonable excuses regime for inaccuracy penalties, but tougher gateway conditions. The penalties will only apply if there's deliberate error or careless behavior, and careless here means lack of reasonable care. One interesting case that I would point people towards is Patrick Cannon against HMRC. That case sets out that if you have received advice from someone who holds themselves out as competent to advise in an area and they're a professional advisor, and you take on board that advice and follow it, you almost certainly have a reasonable care argument to be made, unless that advisor is making very obvious errors. Okay, I'm going to move on now to Isobel, who's going to talk about holiday accommodation.
Thanks, Bob. So holiday accommodation gives rise to a number of queries on whether it is or isn't residential property for LBTT and ADS purposes. The starting point is the test for whether something is a dwelling or not, and this is the LBTT test. So it'll be a dwelling if it's used or suitable for use as a dwelling, or in the process of being constructed or adapted, and then the land which forms part of the garden or grounds. So the first test, as we'll see on the next slide, before we get to that, it's used at the time of the purchase of the property. It doesn't matter what the future intentions are, and it doesn't matter if the previous use was something else, although habitual use does sometimes get taken into account, as we'll see on the next slide. It needs to be fairly kind of typical use, not, for example, use by squatters. That wouldn't mean that something was being used as a dwelling. So moving on to the holiday cottages and lets, first of all, the first test is whether something is being used. So if something is being used as a dwelling at the time of purchase, it is a dwelling. But the second test, if if it's not being used as a dwelling, is it suitable for use as a dwelling? And here there is quite a difference in approach between Revenue Scotland and HMRC. And I should mention that HMRC's guidance obviously isn't binding on Revenue Scotland at all, but HMRC's guidance on the whole area of residential and non-residential property is much more extensive, and so can be quite helpful. In terms of holiday homes, Revenue Scotland are quite convinced in terms of their guidance that holiday homes and lets, including those which cannot be used all year round, are considered as dwellings. So that's really their sort of only published guidance on the topic. However, HMRC go into it with a bit more of a nuanced approach. So for holiday chalets or holiday lets, they say something that was being used for short stay by visitors would not be being used as a dwelling by the short-term visitors. So the use test would not be met, but the chalet may still be suitable for use as a dwelling. And that would be a question of fact in each case, depending on the wider context. But HMRC do accept that if there are restrictions on planning where you can't use the chalet out of season, or where each person can only stay for a maximum of 2 weeks or something like that, then that certainly indicates that the chalet would not be suitable for use as a dwelling. And you can see that Revenue Scotland should perhaps take a more nuanced approach themselves, because whereas some holiday properties are really just second houses that people might let out from time to time, there are certainly some categories of chalets and so on which really aren't suitable for use as a dwelling because you just can't stay in them for long enough. However, we do rely on Revenue Scotland's guidance to claim multiple dwellings relief in relation to holiday properties. So it's a question of just being aware of the fact that Revenue Scotland's guidance probably doesn't go far enough. What about hotels, bed and breakfasts, and so on? A building that's being used as a hotel or inn or similar establishment, according to the LBTT legislation, is not being used as a dwelling. And where it's being used as a hotel or inn or similar establishment, no account is to be taken of its suitability for use for any other purpose. So if you can, if you have a building which is being used as a hotel, then it will not need to be considered whether it's suitable for use as a dwelling. What does use as a hotel or inn or similar establishment involve? Well, the services that are supplied, the length of time people stay, the ability to book for short periods of time, whether there's a restaurant, a coffee bar, and all of that kind of thing will all be indicators of whether it's being used as a hotel or inn or similar establishment. But in terms of guidance, it's the only bit of guidance is really some SDLT guidance on bed and breakfast establishments. So HMRC say a bed and breakfast establishment which has bathing facilities, telephone lines, etc. in each room and which is available all year round would be considered non-residential in line with the relevant bit of the SDLT legislation, which says that it's not being used as a dwelling. So it's really a question of the configuration of the guest house or bed and breakfast, and whether it is being used more as just a place for people to stay rather than a long-term residence. So moving on to a few of the recent cases, which I'll just mention very, very briefly. in terms of whether something is suitable for use as a single dwelling, which is what you would need for a multiple dwellings relief claim. There have been a lot of SDLT cases and a couple of LBTT ones too. In the SDLT cases, the revenue seemed to be winning all of them. So in the George case, there was a main house and an annex, but the tribunal judgment said that the security and privacy of both the main house and the annex were compromised by the access arrangement. So there was a sort of communal access arrangement, and that meant that neither property was really suitable for use as a single dwelling. Also, the absence of kitchen facilities played into the decision, and this concept that the annex was only suitable for use as a dwelling by a particular type of occupant, whereas the important thing is that it's suitable for use as a dwelling by any type of occupant. In the Fiander and Brower case, there was a corridor between the main property and the annex, but no door. So again, a lack of privacy and security, which meant that the annex wasn't suitable for use as a single dwelling. In the Mullen case, there were actually quite a lot of helpful comments, which would be helpful to taxpayers. So the shared use of a glass conservatory between the main house and the annex were irrelevant. There were large windows, which arguably didn't allow privacy, but that was not relevant because that's the case in many houses. There was no access to the garden, but again, that was held to be not relevant. But what the main issue in the mind of the tribunal judge was that there were unsafe cooking arrangements in the kitchen with a sort of higgledy-piggledy setup with things being balanced on top of other things. And so on that basis, it wasn't suitable for use as a dwelling. So the bar is quite high in terms of what a single dwelling is. And it's important to bear that in mind before going down the route of trying to claim multiple dwellings relief, relying on an annex, particularly if you're trying to change the LBTT return after it's been submitted. I'll hand back to Bob now to talk about missed relief claims.
Okay, you'll be relieved to know that this is going to be very brief. If we could just flip onto the single slide for this section. The reason we thought it would be helpful to talk about this is because we're aware that there are a number of claims farmers currently operating, writing to people who have made particularly large residential purchases that they've seen recorded in the land register, writing to say, we believe you've missed a claim for multiple dwellings relief. This is the most common one, and we can get it back for you, charging usually a fairly significant fee for doing this, and in some cases touting the line that the relief can be claimed up to 4 years after the date of the transaction in question. So we just wanted to put to bed some of the kind of nonsense that is going around on these. There are two ways of reclaiming overpaid tax, and if you fail to claim a relief, you are largely looking at overpaid tax. The first one is via the amendment process. This is the taxpayers having a statutory right to amend returns within 12 months of their submission. This is a taxpayer amendment that they're entitled to make, which means that the revenue don't have any statutory right per se to refuse it. Instead, some revenue authorities and occasionally Revenue Scotland will process refunds on a pay now, check later basis. If they disagree with the amendment, they can then launch an inquiry. They have a four-year window in which they can launch inquiries, and they can do this after the fact, after a repayment has been made. Some a point I would make about claims farmers here is that they often will just lodge a statutory amendment as if they've done something great. The funds will come out, they will take the fee from the client, and then the revenue will check later, launch an inquiry, at which point, I would query whether the claims farmers have, say, a fighting fund for dealing with this, but often the client can be put out of pocket as a result because they will lose the saving they thought they had gained. The other method for dealing with overpaid tax is an overpayment relief claim under Section 107 of the RSTPA. This can be done up to 4 years after the fact. It must be applied for, but there are a number of exclusion cases in Section 113, and the very first of these, Case A, says that the revenue do not have to give effect to an overpayment relief claim if it's being made because of a mistake in making a claim, i.e. mistaking in calculating or a mistake in claiming or not claiming a relief. So the general view and the general consensus amongst advisors is that overpayment relief is not available in order to make a belated relief claim. It really has to be done via the amendment procedure within 12 months. I've put down there alternatives. Can you void the return and resubmit it? I think we've successfully done that twice. Once when there was no tax to pay, but we wanted to claim the relief because the transaction was a leasing transaction and we didn't want to have to submit 3 yearly returns. And once because the tax-paying entity was a church with a complicated trust structure, and we were able to argue that the original return had gone in the name of the wrong entity in that structure. So it hadn't been submitted on behalf of an actual taxpayer and should be voided on that basis. And then the new return could claim the relief. Those circumstances are few and far between. So 99.9% of the time, it is the amendments procedure only, 12 months. Back to Isobel.
Linked transactions. I'm sure everyone's aware that linked transactions are those which form part of a single scheme, arrangement, or series of transactions between the same buyer and seller, or persons connected with them. And how they can arise is if you've got heads of terms that link things together, if there's a pipeline of transactions that's expected, if you're agreeing to buy some properties now and some later. And the LBTT is calculated as if they were a single transaction using the aggregate consideration. So the effect of that is that one nil rate band is apportioned between all of them. And the LBTT payable for each one is apportioned based on the consideration, the proportion of the consideration for that transaction. Leases, there are two types of linked leases. Leases of different premises between the same landlord and tenant or parties connected with them. So that's sort of sideways linking. And again, you calculate the LBTT as if it was a single lease. Or there's also the concept of a successive linked lease, where it's successive leases of the same premises between the same parties, but they do have to be linked. So the question of whether things are linked or not is one of these things where if you're thinking about whether it's linked, then it probably is. Where you've got a linked transaction, or where you've got linked transactions, I should say, they can be reported as a single one if they all complete at the same time, but then that could cause issues if one has to be separately dealt with or has a separate sort of turnout in the future by being a linked lease which is surrendered or assigned or whatever it is. So it's often not the best approach. Where a transaction's linked to a previous transaction, that can lead to additional LBTT on the previous transaction, and there could be a requirement to amend the previous return or indeed to put in another return. And then if you have a third linked transaction, you've got the LBTT on the previous two. So even more returns might be required. So a practical approach which can be adopted, which is I think mentioned on the next slide, is that when you submit the first return, give it the full benefit of the full nil rate band and the lower bands. And then for subsequent returns, just pay LBTT at 5%. And Revenue Scotland have accepted that this is a way to proceed that they don't really have a problem with. They get the same amount of LBTT at the end of the day, but it avoids the need for multiple amendments and multiple additional returns and so on. There are some advantages to linked transactions. If linked transactions include a non-residential property, LBTT is paid on all of them at the non-residential rates. And MDR can be claimed if 2 or more dwellings are purchased in linked transactions. So this means you can pay LBTT at the non-residential rates on the overall purchase, but still claim MDR on the dwellings. Although bear in mind that the 6+ rule doesn't apply to linked transactions, only to purchases in a single transaction, which is a different concept. This means that the 6+ rule you won't be able to get across linked transactions. Bob.
Okay, very quickly then, when can ADS be charged on a main residence? This is a bit of a bugbear of mine. We've only got a few minutes left, so I'll go through this relatively quickly. There is a link to some reading materials at the end. Also just want to make the point that because we are running low on time, if anyone has any questions, do feel free to type them in now rather than waiting until the slide that says questions. So ADS 101. This flowchart really is how I think about the ADS whenever I have to look at it. I start by asking, are there 6 or more dwellings in the single transaction? Is it a property letting business that we're dealing with? And then we get on to for individuals, the meat of the ADS test. At the end of the day of the purchase, will the buyer own or be treated as owning 2 or more dwellings? If no, the ADS doesn't apply. If yes, the ADS will apply unless they fall into the main residence replacement exemption. Now, my bugbear is that lots of people seem to refer to the ADS as a second homes tax, and it isn't. They also frequently say or argue that the ADS cannot apply to XYZ because it is going to be a main residence. And my point here is, if you look back at that flowchart, you'll see the words main residence apply only once, and that is in connection with the replacement main residence exemption. There is no general get out for buying a main residence. It is only when you fall into the exemption that the main residence you're buying is exempt from the tax. Because of the way the exemption and the accompanying repayment provisions are framed, there are a number of difficult situations where the tax arguably shouldn't apply and it does. These are family separations, long-term renters, couples who are taking it slow, and also anything involving partnerships and trusts. And I just want to canter through a couple of these examples to give you a feel for the kind of issues. To my mind, probably the worst one is family separations. In this example on the facts, Edgar and Lenore bought their marital home in joint ownership 50-50. 7 years later, they separate. Edgar moves out, and quite common thing to do, he keeps his half share. He rents for 4 years and then buys a new home. At this point, Edgar will have to pay ADS on the purchase price because he is caught by the 2 or more dwellings test, and he cannot recover that ADS because to qualify for a repayment, he needs to have both disposed of his old home within 18 months of buying the new one and lived there as his main residence in the 18 months before buying his new property. What that means, particularly that second point, is that if he sells his family home after he's bought his new home, then he is stuck with an ADS charge that he cannot get rid of because he just does not qualify for replacement of main residence. Next slide. Again, a family breakup situation. Lavinia moves in with her new partner Wilbur after their marriage breaks up. She owns a half share in her previous marital home. Wilbur doesn't own anything. They rent for a few months and then they buy a flat together, again in 50-50 shares. This takes place a year after Lavinia's moved out of the marital home. They pay ADS on the purchase, and 2 months later, Lavinia sells her share of the marital home, either back to her husband or to a third party. You'd think now you should be able to reclaim the ADS that you've paid, but again, you can't. And this is because the ADS rules are bizarrely prurient and prescriptive about people's private lives. One of the quirks in these rules is that couples buying together, if you want to claim the replacement main residence exemption or repayment provisions, they have to have both lived together in the house being sold as though married to one another. In this circumstance, because it's Lavinia's previous marital home that she lived in with her husband, it's pretty unlikely and also pretty understandable that they did not do that. So on those facts, they cannot claim the refund for the ADS they've paid. A version of this also arises for couples who just decide to live apart and then only move together when they're buying together, and usually when they're married. Final example, very briefly, partnerships. Ron's parents are farmers. They assume him into the partnership at a minimal stake, say 5%, and the farming partnership owns the farmland and some workers' cottages. If Ron goes and buys his own home for himself, even if he owns no other dwellings himself, he'll be liable for the ADS. And this is because the partnership rules treat him as owning everything in the partnership. And so that catches him out on the 2+ test. He's not replacing a main resident, and so the ADS charge applies and it sticks. There's no exemption for the fact that these are effectively trade-related properties, or for the fact that his stake in them is incredibly minimal. In fact, if he held less than 1%, he would still be liable for the ADS. Final slide. I have recently written an article that was published in the journal on this. I'll link to it on the slide, so there are some more examples and a bit more discussion, but I just want to reinforce my previous point. ADS is counterintuitive, more than just a second homes tax. There is a forthcoming consultation, and really I'd encourage anyone who has to deal with this on a daily basis to write in to the Scottish Government once that consultation opens.
Well, thanks very much, everyone, for joining. We've answered some questions just by typing the answers, to be honest. And if you have any other questions which you'd like to raise, please do send us an email. But we're conscious that we've come to the end of the allotted time. So thanks very much indeed for joining. And as we say, do get in touch if you have any other queries.